my name is Simon Flamand. I'm an exchange student from Belgium and I'll talk to you about the protection of spare parts under copyright and design law. In my presentation, I will first focus on the Australian legislation, then I will show the interest at stake which tends to influence the legislation, and I will finish by a quick look at the other jurisdiction. Let's begin by the system in Australia. Spare parts can be protected by design law if they are registered as a separate design. They must therefore satisfy the conditions of newness and distinctiveness, as you know. However, there is a very important exception to the protection given to spare parts. Under the Designs Act 2003, section 72, there is a spare parts defense to design infringements, which means that you cannot enforce design law and its remedies when a spare part is used to repair a complex product. What is the exact scope of this defense? It applies only for the use or the authorization to use for the purpose of the repair of the complex product. Repair is defined to include restoring or replacing damaged components as well as carrying out maintenance. If spare parts are used for another purpose, there can still be infringement. For example, IKEA cannot sell all the parts needed to assemble a Ferrari in a kit form to get around basic design protection. A complex product is defined by the Designs Act as a product including at least two separable components, parts permitting disassembly and reassembly. Those component parts are something made separately from the product. So, spare parts which fulfill those conditions can be reproduced and sold lawfully without permission of the holder of the design right. This is a huge exception to the protection of spare parts, even if they are registered. But why is there such a restriction to the rights of those having registered a design for spare parts? Before the adoption of the 2003 Act, under the 1906 Act, spare parts could be registered without limitation. The problem there is that it affects negatively the consumers by reducing the competition in the supply of repair and replacement parts. Previously to the adoption of the 2003 Act, the Australian Law Reform Commission considered that spare parts should be protected, but with some steps to prevent anti-competitive conduct in the procedure of obtention of a design right. This approach was not adopted by the government, which preferred to grant design registration with a defense to allow use of designs for repair. There has been complaints from the Australian car manufacturers, who feels disadvantaged by the situation because the Competition and Consumers Act compels them to keep adequate supplies of spare parts at hand, but repairers and insurance companies tend to purchase parts from overseas rather than through Australian companies, leaving these Australian companies with huge stocks of spare parts not used. Those imported parts are either aftermarket parts produced by third parties or unauthorized original equipment manufacturer parts which are licensed overseas but imported in a parallel to the manufacturer's official distribution channels, so outside those official channels. Nevertheless, there was a report from the Commonwealth Consumer Affairs Advisory Council examining the supply of automotive repair services, which found that there was a wide range of services available to consumers and competition on this market. The protection of car spare parts is only a small element of the spare parts question, and the Advisory Council on Intellectual Property has not received any submissions from another sector, therefore assessing that the current system can be seen satisfactory. Now, I will examine the protection of spare parts in other jurisdictions, the US and the EU. In the United States, it is very different from Australia. The design patents do not need to cover the entire product to be registered, so spare parts can be protected by design law, as in Australia, but there is no defense. Therefore, aftermarket spare parts manufacturers cannot legally produce spare parts copying the registered design. They have to make a substantially different part from the authentic one. Now, in the EU, it is much more complicated. At first, there are some specific replaceable parts which cannot be registered and thus protected. Those are the must-fit parts. A must-fit spare part comprises features of its appearance which must necessarily be reproduced in their exact form and dimensions in order to permit the product in which the design is incorporated or connected to perform its function. The design is therefore bound to a technical function. There is no alternative possible as regards to the shape of the design. Those cannot be protected. Then there are the must-match parts. These are spare parts whose shape and configuration is dependent on the shape and configuration of a complex product, but where there exists an alternative in design. This relies more on the appearance of the design than on its functionality. For example, a car door. For those parts, no consensus has been reached between the European states. The EU Commission has proposed a repair clause, which, if adopted by member states, allows the manufacture of must-match spare parts without authorization from the right holder. This proposal was brought in order to liberalize the spare parts market. In order to invoke such a repair clause, the manufacturer has to prove the objective necessity to imitate the original spare parts, and this must be done with the purpose of repair. However, not every country in the EU has yet adopted the repair clause. For example, France and Germany remain with a legislation protecting the original manufacturers, while countries like the UK, Belgium or Italy have adopted such a repair clause. In conclusion, it can be said that the debate for the liberalization of the spare part markets is not yet settled in the world, but in Australia, the legislation allows the use of non-original spare parts for the purpose of repair. Thank you for watching.